before you do that.
Awesome. Well, good morning. Happy Friday to each and every one of you. Thank you so much for taking time from your business to be on this call with me and Rinat. Rinat is a phenomenal attorney, is part of our real estate risk management team. Her and her partners have an office in Los Angeles. She's been practicing for many years, and now is going to provide us with the ins and outs of the most updated contracts in the real estate realm. Without further ado, Rinat, welcome. Thank you so much.
Thank you. I'm going to talk about 27 forms, and in order
27.
to, yeah, I know, right? I mean, I was looking at them last night when I was preparing, and I thought how lucky I am that I'm not a real estate agent. I mean, I don't know how you guys do this. It's absolutely crazy. So let me share my screen and tell me if you can see the first form, which is California Residential Purchase Agreement.
We can see it.
Okay. Is this better when I make my screen a little bit smaller so you could see more of the form?
No, I think we need to expand it more so we can see
Okay.
a little bit more.
Let me see if I could. Oh, I know. Okay, I know what to do. Okay, now it's perfect. Okay. Let me do it a little bit smaller so you can see at least the full page. I would encourage people to ask questions if you have any while we go through these, because honestly, the changes are a little bit tedious. I could tell you why they were made so you understand the idea behind of it, but at the end of the day, you're gonna take a form and you're gonna use it, and whatever is on it and is on it, and you don't always need to select something, so you don't necessarily need to know what was changed. There are a few new forms, and I definitely want to talk about them. Of course, the broker always encourage you guys to use as many forms as possible. That's why they are for you. And when you go through these forms with me, you'll see that some of them are more advisory, basically more forms to protect you, more disclosures. So even though they're not mandatory necessarily, they might actually help you. Okay. So starting with the residential,
if we could make it a tad bigger, it would be easier for us to see.
Absolutely.
Okay.
Rinat,
Oh, wait, this is too big. How about this?
That's a little too big. Just go a little bit wider, and I think we should be okay.
No, I could do this. Actually, is this good?
No, it's not.
No. Oh, okay. Sorry.
Do it a
I'm
little
so sorry.
bigger. Right there. Try doing that. Keep going. 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 Keep going.
That's good.
Almost there.
I think that's good.
Okay. Perfect. Right.
Okay. So we're gonna see half a form. That's fine. We're just gonna go slow, and I'm gonna scroll. Some of the forms don't have an indication what the change was in a different color. So I'm gonna put my cursor around, and hopefully you can see my cursor. Okay.
Yes.
So the first change that was made was on page 1, and this is one where it's identified, and you could see here, basically it gives the option of paying points. So not only is the buyer committing to a certain percentage of interest, the buyer's also committing to whether they're willing to pay points or not. So this is a small addition. This is a little bit of a slightly bigger addition because there's another form that actually talks about this. Seller agrees to pay the buyer's obligation to compensate the buyer's broker. So if there's a separate agreement between a buyer and their broker, which we're going to talk about today, the seller is going to agree to compensate that broker. 3M was also changed. I look for 3M. Here, basically, the statement here is who's occupying the unit. Is it the tenants or the seller or somebody else? and here is a disclaimer or advice, if you will, on the right. It says seller should disclose to buyer if occupied by tenants or person other than seller, and attach a TOPA in a counter offer. Okay, so this is again reminding the seller to attach a tenant occupied property addendum. Paragraph 7 is the next one I was going to talk about. This is just another advisory, so you don't have to be concerned with that. 7 here is if the buyer intends to occupy the unit and it has several units, the buyer's going to have to say which unit they're going to occupy. So it's more of a disclosure. There's nothing for you to do here. 9B. This at the top, it basically adds some hardware for the curtains, and at the bottom it talks about reminding, I guess, the seller to delist services that they have, security or whatever it is that they have with the property. Again, it's in the forms. You don't need to know about it. Just telling you so you know that it was there. Shouldn't concern you too much. 12B is a little bit interesting because, let me see. Oh, so here there's another solar disclosure form. So it mentions here that it's going to be discussed. But I wanted to show you 12B. Basically, this says that the contingencies also includes a review of the seller's documents. So you know how the seller has to provide documents and then the buyer has the physical contingency. So now it clarifies also that the physical contingency pertains to, or maybe this will not call it physical contingency, but a contingency that the buyer has to approve that they review the seller's forms. I'm going to go to 23 is basically just talking about the assignment. I get a lot of assignment questions. So basically, if there's an assignment, you know, escrow needs to know about it, and that's what it says at the end. And if it's just a nominee of the buyer, then you don't really have to do an assignment. So again, it's in the form, nothing too much for you to worry about. Okay, so this is the longest form. And there's some, so here's some legal language in the arbitration, and this was kind of separated and cleaned out with address and email. So this is still the RPA. Okay, now we are on the second form. The second form is gonna be new to you. It's gonna be familiar, but it's new because it combines a bunch of forms. It combines the exclusive and the non-exclusive buyer broker compensation into one form. It's encouraged that you guys use this. It's always nice. It makes it easier for you to make a claim for your commission if some other agent kind of walks in and swoops and takes your client away, so you can make a commission claim to show you are the procuring cause. I always recommend to sign it. I know it's kind of hard when you're working with a buyer to tell them, hey, can you sign this form? But now they don't have to be worried because they don't necessarily have to compensate you if separately. So paragraph 1. Paragraph 1 I wanted to talk. So here's where I put my cursor because hopefully you could see it because there's no highlight here. It talks about beginning on a date and ending after how many days. So it doesn't say a date, but days. So you're going to say, I'm going to be your agent for 30 days, 50 days, whatever. So you put here the number of days. So that's one thing that's different. And then if you look at number 4, compensation to broker, it reverts to the non-exclusive. So if you look at 4B, broker right to compensation, it's going to be non-exclusive here. It's basically going to be if the buyer or lessee enters into a contract, the compensation is going to be based on that agreement with the listing agent. But here, it has this or. okay? And you could turn this into exclusive representation. And if you mark it, then brokers entitled to compensation, whether or not the broker was involved. So if you work with a buyer and they go and use a different agent purchase the property, you're still going to be entitled to compensation. You could present this to the escrow, you could present it to the listing agent, you could pursue a claim for procuring cause. You are going to be entitled to compensation. You don't have to prove what you did. Here, there's a signed agreement. Buyer agreed to compensate me. Okay, so that's very important and helpful if you want to do it that way. Another thing that was added here is the cancellation. So if a buyer is concerned, oh my God, what if I decide I don't want to look at more properties? I don't want to stay with you exclusively for 90 days. No problem. Just sign this cancellation. No problem. You can sign it, and there's a cancellation provision, but here it tells you that you can cancel it. 4D is also interesting because it talks about how the broker is going to be compensated. So, and there's another form that we're going to talk about it, where you're telling your buyer exactly where the money's coming from for your compensation if you're a selling broker. So that talks about that. And then, oh, in 4D3, you'll see here authorization to include the commission. So basically, remember how before we talked about the RPA, where it was added that the seller is going to pay the buyer's broker's commission? This is sort of how these forms work together. All these forms, whenever you change one, you have to change all the other ones, so they all work together. So make sure when you're using this form, you also use the new RPA, of course. So this is why. Okay. This is also interesting. The 4F, you're disclosing anticipated payments to broker by others, and like I said, there's another form, but this is in the agreement itself that you're going to provide a disclosure. Okay, that's all I have to say about this agreement. So we could scroll down quickly to this one. Anticipated broker compensation disclosure. So this is kind of what I was alluding to. Now you're telling your buyer, hey, how I'm going to be compensated. Why do you want to do that? Well, when you're representing a buyer, you're acting as their fiduciaries. And as a fiduciary, one of your obligations is to make sure your principal knows all the ways and forms that you're going to be compensated by, whether it's a commission coming from the seller, whether from them, whether anything like that. The way the forms are written now, it's fine. Escrow usually sends out a commission statement, and the buyer and seller sign it. So I'm pretty sure that, I'm not sure the buyer sees those, but the seller does. So hopefully the buyer sees them. There are a lot of ways for the buyer to figure out and know how much you're going to be compensated, but this is kind of there in bold, right and center. Here it is. This is how much I'm going to be compensated. So again, you don't have to use this form, but it's kind of nice, because what I see a lot of times in lawsuits is that the buyers say they didn't know how much commission their agent was making. They didn't realize how that affects the price they're paying, because of course the higher the commission the broker's making, the higher sell price the seller wants to sell, because they have to account for all their expenses. So this kind of, to clean that up, it's kind of nice. That's really all I have to say about this form. It has two sections here where you fill out the first section about, hey, this is how we're gonna be compensated, and then here where you actually fill it out. That's about it. It's pretty self-explanatory. Okay, This is buyer transactional advisory. Another disclaimer to a buyer. Why would you not use it? Beats me. The more these forms are used, the better you are protected. And I'm telling you, we go to trial and we blow up in front of the jury specific language and disclaimers and show it to the buyer and say, and you signed this, and this said this, and this form said that. And we go on and on and on about talking about, limitations on duties, reasonable care and all that. Why is it good? In addition to disclaimers, the law says that your duty to your client is based on statute and based on agreement. Well, statute is easy. The statute says you have to fill out a TDS. Okay, you fill out the TDS. The AVID is not a statutory form, but it's a way for you to do your diligent inspection that you have to do pursuant to the statute. Okay, great, you do that. But what is the agreement between the buyer and the broker? The buyer could say, we had an oral agreement, and the oral agreement said that my broker is going to do this and that and check permits and talk to neighbors and interview the other homeowners in the association, all these things. You're saying we never had that agreement. Well, what do you have? You have an oral swearing contest, whether there was an agreement or no agreement. What does this agreement or disclaimer do? For example, it limits your duties. So I know if you've heard me before, you've heard me say that when a broker gets sued, the body of law that gets applicable to the case is both statutory, the statutes that apply. And there are really only two statutes mainly that apply to us. One of them being the TDS and the other saying that we have to do a diligent visual inspection. And then the other is a body of law of cases that go on appeal and then they come back and now you have a court of appeal decision. Well, there's a court of appeal decision that was used several times and got tweaked to other scenarios. The first time that the case went on appeal, it was a buyer who said that the broker owed her a duty to provide advice about a 1031 tax exchange. Well, in that case, the underlying trial used the statewide advisory, and if you remember, at the end of the statewide the statewide advisory, statewide buyer and seller advisory, there's like a rectangle, and it says brokers do not, provide advice about blah blah blah, and it says something about brokers do not provide tax or legal advice. Well, that sentence was used to say that there was an agreement between the buyer and their broker that the broker's not going to give any tax advice. That was upheld on appeal. It's since got modified in other cases with similar situation, not necessarily applicable to taxes, but they narrowed the huge and broad fiduciary duty. This is a form that does it even more, okay? Because it says here, obligations and limitations. This is all our limitation. Scope of agent's duties. This is the scope of our duties. We did not decide what you should pay. I mean, some of it is in the statewide advisory, but again, you want to use these forms, they help you, okay? So, and now they've been also adjusted to go together with this buyer broker agreement that we talked about. So definitely I recommend, if you don't want to use 100 forms, don't use them, but use the ones that are advisories. They help you. Okay, now, okay. We're moving to the next form, cancellation of buyer representation. Remember when we talked about the buyer broker agreement and I said, you don't feel comfortable presenting it. There's this cancellation paragraph. Well, here's another form that could be used to cancel the agreement. The reason that CR came up with a form is because it's a legal document or it's a legal relationship. When you have a written agreement, you need to cancel it in writing. And, CR doesn't want you guys to practice law, so it's providing these forms where you could just mark X's in different places. So this basically, it goes together with the BRBC, this buyer broker agreement. But you could use it for any cancellation of any representation. If you don't want to work with your buyer anymore, even if there's no agreement, you could present them with this form so it's clear, I am no longer representing you. Like if they want to do something unethical, if you don't get along with them, whatever it is. And it also mentions here under compensation, okay, what is the compensation I'm going to get even though we're canceling? So if it's mid-transaction, are you going to get some compensation from the commission and so forth, okay? And like CAR is now doing with the revised RPA, they have these beautiful paragraphs over and over and over. Buyer to obtain other advice, talk to a real estate qualified California professional. Okay. It just again says, hey, this is a legal form. We're not giving you advice. There could be a unilateral cancellation. You fill out the top part, or a mutual cancellation. Okay. Very simple. It's here to help you. This talks about just the various expenses that were incurred. For example, if you spend some money helping the buyer and so forth, they might agree to pay if there's a referral fee involved. Again, the form is very simple to use. I know the first time you have to actually read it, but you go through the paragraphs and you just fill it out. Okay, this is a notice of broker involved properties. Again, it all goes together. Remember, we talked about that. So you have the buyer broker agreement, and then you want to cancel it. You have the cancellation form. Now you're saying, hey, other brokers, I was involved here. Just FYI, you're going to owe me a commission. Again, great form to use if you're going to file a procuring cause arbitration. So it talked about how, from when to when you were representing this buyer, and so forth. And then it talks about these involved properties. What are the involved properties? Well, if the buyer physically entered and was shown the property by broker, it's my contention that made me involved, I'm going to be entitled to commission. Or if I show the buyer this property virtually. See, it goes through all these things that you did to be a procuring cause broker. It just kind of cleans it up, mentions it. So this is only going to be used if it's necessary. Okay. Seller payment to buyer's broker. Again, going back to the RPA. Remember that little paragraph that was added about seller payment? Remember how it was mentioned in the buyer broker agreement? Well, now there's this whole form, and you provide this form to the seller, and they agree to pay your compensation if that's part of what the buyer's paying you. Remember, the buyer could just pay you. They can pay you in addition to the commission you're getting. They could pay you a fixed fee. They could pay whatever. But this is where you use it if you have a buyer broker agreement and you want the seller to pay part of that commission or all of that commission. Okay, very simple form. Okay, next form, lease listing agreement. Okay, the first thing that was changed in all the rental agreement and for leasing and all the leases and so forth is that the word owner's been replaced by rental property owner. And this is just to make it clear that you could have a property manager rent or somebody else who's not the owner, and then they could sign the lease basically. So that's one thing. There is an optional paragraph that was added here about okay, so first, this just clarifies personal property will not be maintained by the leasing RPO, who's the rental property owner. Okay, but compensation, there was something added here, and that is in, I believe it's D. No, actually it's E. Okay. So it's basically clarifying that there's going to be a compensation offered if the tenant acquires the property during the lease of the term. Okay, so that's obviously you would want that. The tenant payments here just clarifies where they go to. So, and again, you know, I'll say this: the DRE is coming down on property managers more than they would on brokers, and that's why a lot of brokers don't allow their agents to be property managers. The reason is because of the trust fund. Okay, you're collecting a deposit, and it has to be in a trust fund. So, definitely you don't want to be compensated from the security deposit. This is kind of a trust amount. But other than that, I mean, it kind of says, how's the broker going to be compensated? Is it when the first month rate comes in at execution, possession, other, things like that? B is also an addition because it basically talks about electronic payments. Now everybody's using Venmo or Zelle or whatever. So that kind of makes it more modern. One thing that you want to consider is this indemnity paragraph that was added. Okay, this just kind of talks more about the duties of the owner or RPO to consider reasonable offers and all that. But the indemnity is here. You definitely want to use forms that have indemnity in your favor. I want to tell you a story. And you'll see also in the property manager agreement. I have a big property management company that I represent. They were quoted insurance. They manage 8,000 units, and they were quoted close to $1 million insurance to insure the 8,000 units. I talked to them and I said, why don't you mark the indemnity agreement in each one of your property manager agreements and give, because they didn't have 8,000 agreements, right? A lot of these properties belong to one owner, and a lot of these properties are large. So they had, probably a few hundred property management agreements, and then show that to the underwriter who insures you and say, look, your risk has been reduced because not only do those owners owe indemnity to the property manager, they also have to put the property managers an additional insured on their policies. It reduced their premium from close to $1 million to $50,000 a year. That was huge. So these indemnity agreements, they are very important. Okay, now there's a termination of agency clause added. Again, just to be clear when the relationship ends. This is something that was added on attorney's fees. You know how it says now here that everybody's responsible to pay their own fees. I want to be clear. CDR is taking the position that in all these forms with consumers, we're gonna have everybody's gonna be responsible for their own fees, except for the listing agreement where you could get your fees if you want to sue for a commission. And the reason is that those fee agreements end up being the reason that you get sued a lot of times. There might be a small issue, like a $5,000 lease repair issue. And if the tenant or the owner or whatever knows that they can get their attorney's fees, they just will slam you. They won't settle. And you have cases where the value is $5,000, but the attorney's fees are $100,000. So from a defensive mindset, CAR decided, and this is years ago, to have everybody responsible for their own fees. Now, in the RPA, there is a fee agreement between buyer and seller, but it says that broker is not a party to this agreement. So the fee agreement doesn't apply to the broker. So the first thing that when my clients get sued, I say, hey, just so you know, whatever you spend to pursue my client, and it's going to be, $100,000, you're not going to get it back. So it's going to come off of whatever you recover, if you can ever recover. So now they added it to this as well. I just wanted you to understand the importance. This is another provision that I find very important to my broker clients. Like I said, a lot of brokers don't let their agents do any property management. And this provision says that if a sales associate signs this and then the broker finds about it later, they could cancel the agreement. So they may not find out that what you're doing, but it just gives your broker the ability to cancel it. And that's pretty much it, what I wanted to talk about this form. Yes. Okay, property management agreement. So I talked about it a little bit in the prior forms. Okay, first of all, the word owner was changed. We talked about that. It could be canceled. So early termination, you have to give 30-day notice. But if there's pause, meaning either the owner or the property manager did something bad, then you could terminate for cause without 30-day notice. So that was added. Direct electronic payment, we talked about that. This also gives the tenant the opportunity to pay directly by electronic payment. This again clarifies the expenses. Again, it just cleans it out, makes it more clear who pays what. I've seen thousands of property management agreements, and not the CAR ones, but ones that different management companies create on their own. And a lot of them would say something like, broker's responsible to obtain insurance. Okay. But then in reality, the owner goes and gets insurance and pays for it directly. Well, then and then there's a claim. And then the insurance company denies the claim. And then they sue my clients and they say, hey, you didn't get me the right insurance. Okay. So if you want the responsibility of getting insurance, it is a responsibility that you undertake contractually. And you have to make sure you get the right insurance and a good insurance, right? And I'm not saying that you're supposed to be proficient about insurance, but if the insurance doesn't cover mold, you should know that. And if it doesn't cover certain things, you should know about that. But here, it kind of cleans up who pays for what. So remember, not only who gets what, but also who pays for what. So,
Rinat?
Yeah, go ahead.
Hi, Rinat. One of our agents has a question for you. Gina, go ahead.
Oh, thank you. I was waiting till the end, but you probably covered this in one of the forms because I see so many different forms here that I'm not totally familiar with. So this really helps. But say you sign the, I think it's the buyer broker agreement. I can't remember exactly what it's called. And you have an agreement for whether it's 30 days or a week or whatever it may be. Whatever properties that you've shown them, I think it showed them one of the other forms. Somehow you can document, like say you showed them 20 properties during that period, and you want to make sure if they buy that property 6 months from now or whatever it is that you're going to get paid, just ensuring that whatever you showed them, you get paid on. How do I cover myself?
So we have to, so the form, we looked at one form that you provide to an owner of a property that talks about like broker interest. Hey, just, I have some interest. So you would give it to each seller. So,
okay.
If you've seen, I mean, it's a question. If you've seen 20 properties or shown 20 properties and the relationship continues, you don't need to do anything because they're still your client and you're going to be making the offer. But if the relationship terminates, you're going to know which properties they've seen. You have to go to each one of these owners or listing agents and say, I have an interest in this property. I have an interest in, so that they know. Otherwise, those properties that your clients have seen, these owners and listing agents won't know that you've shown them, especially if it's virtual. So that's how I think you would do it, unless somebody has a better idea. I mean, I guess what you could do is fill out one form and just email it to everybody, the same form. So that would be my understanding. Okay, so we talked about this. Limitation of payments. This is just to clarify, like, what's your limitations? I can repair anything up to $500 or without approval or things like that. This is a new form. If you see here, RPO agrees to complete a rental property owner disclosure. Wow, this is another disclosure, and we'll talk about it. Very cool, because this contract obligates them to fill it out. If you signed a different form, like maybe your own or maybe an older form, it doesn't obligate them to fill it out. Why do you want your owner to fill out essentially an SPQ? Because you get sued. So here's what I typically have when my client leases property, even if they're not a property manager. A tenant sues because of something. I respond, hey, we were not the manager, or this was during the prior management company time, or whatever. And then they respond back and say, well, at the time you leased it, you should have known that there's an issue there. So that's where the RPOD, rental property owner disclosure, comes in. No, I didn't know about it. Here's the disclosure that the owner filled out. They didn't disclose about any of that. Okay, so that clarifies it. Indemnity. So remember, we talked how important indemnity is. This adds actions brought by the Department of Fair Housing and Employment. So I've had a few of those. What they do is a tenant, whether they usually a tenant who did not get the property, would file a complaint with the DFEH and would say I was discriminated against, and then the broker has to defend themselves, saying no, there's no discrimination, your rental application wasn't as good or whatever. But then they'll say something like, well, it's because I had a dog, and then they wanted a bigger deposit because of the dog, and it's an animal support, emotional support animal, and that's kind of how it goes. You're paying for your own defense. Well, here it says owner's going to indemnify you. So if the owner says to you, hey, I want a bigger deposit, and if it's not allowed by law, you shouldn't be doing it. But if you even mistakenly did it, here the owner's going to indemnify you. So that just adds to that. This is just, just more explanation about compensation, like, okay, am I going to do eviction and what part of the eviction, and then cancellation, anything about how it's going to be canceled. So just more cool stuff. This is, again, a disclaimer. So property manager not responsible for damage of personal property. And the attorney's fees clause here was changed. Wait, let me see. Okay, everybody is responsible for their own attorney fee. Love it. This is fantastic. Okay, so that's pretty self-explanatory. Legal authorized signer. We've had issues with that, so it just kind of says, hey, I have a right to sign it. I have the title to the property. I have authority. So at least, even if they don't, you could sue them and say, you said you did. You warranted it. Okay, and this is just like the entity disclosure, and then just the signature part. Okay, easy. Rental property owner disclosure. Okay, this is a new form, and I said we're going to talk about it. Think of SPQ. This is kind of like the SPQ. The owner is now going to disclose everything they know about the property. They're going to go through for you. Just make sure. Look, every time you get a form, you need to make sure it's filled out if you give it to somebody, right? And this goes back to even TDS, people missing something on section C or in the SPQ. They don't answer questions. All it says is, are you aware? So they're either aware, yes, or they're not aware, no. But to not fill out and say not applicable doesn't really respond to the form. Because now, if they don't fill it out correctly, and this form is to protect you, and it turns out that they don't fill it correctly, and the one thing that everybody gets sued on later, they're going to say, well, why didn't you ask? Why didn't you get a clarification? So when you actually go out of your way to do something, you need to discharge that. In a way, you create a duty on yourself by now saying, okay, you have to fill out this form. Yes, the form protects me, but in a way, it protects the future tenants who are contemplated here, because now you're going to disclose to them all these things that you know about the property. So in a way, when you go about and ask for those questions, just make sure they fill it out. That's all I could say. Very simple. Just even have a TC go over this and say, hey, this thing, I'm circling it. It wasn't filled out. Okay. Look at the bed bugs. I love that. That's awesome. Just, do you know anything about that? Parking. Oh my God, I've had so many parking cases. Storage. Which storage? You know how sometimes the neighbor might allow the homeowner to park next door, so they think they have 2 parking spaces, but they really only have 1. Or they allow them to use the storage unit. Or maybe 2 property owners have replaced the storage unit location. Okay, I'll use yours closer to me. You use mine. So it just all these disclosures are great to clarify these things. Okay. Residential lease or month-to-month rental agreement. Okay. Here the change was again with the name owner, right? We have rental property owner now. There's a warning that was added to remove photos and other valuables or cars. I mean, if they have a Bentley in front of the rental, they don't want anybody to see a picture of their Bentley. So it's just to tell them, hey, you could just make sure it could be photographed. About it, I think. Nothing too much changed here. Going through it quickly. Oh, paragraph 5 was, I'm looking at my notes. I'm so sorry. Paragraph 5 was changed. Yes, this part, moving in cost. So, you know, how is the payment received? It could be coming in multiple payments. So, you know, if you get 5 checks for the deposit, maybe if it's 5 tenants and each one of them, you know, it's like students, and then each one is renting their own. So you might have 5 deposit checks or something. Just to clarify how the checks are coming in. That's pretty much it. Next one is going to be move in, move out. So this is 2 new forms, but they're really old forms. You know how you had the move in and out form? Now you have 2 forms that are separated. That's really it. You just separated the form. So very simple. Good. So this is going to be the move in. Explanatory. Oh, and there's something where you could designate, I think, if it's new or other, which you could explain. It's not new, I guess. I don't remember if it was in the old form. And then you're going to see the move out. Same form. And it was all added here. Okay. Self-explanatory. We don't have to spend time on it. Okay. This is the right to inspect prior to termination of tenancy. You have to do that. This is by code. The infamous Civil Code section 1950.5. If you ever do property management, please just read that code section. It talks about how to give notice of the right to inspect and how to pay the deposit back. I got class actions on this. I got so much stuff on that. So just be careful. Make sure you know that. This form is just basically mimics the move in, move out, and it includes language to allow for the deposit to be mailed electronically. Yeah, that's it. All we have to know. Application for rent. Again, the rental property owner language was changed. And just credit information if you're getting it. Okay, this is a disclaimer that was added. Do you see this box here with a big circle that says, please check this box if you would like to receive at no charge a copy of an ICR? I want to tell you a horrible story. This attorney basically, this is under an act called ICRA, it's a Consumer Credit Report Act and whatever. And it mentions inside the code section that you have to have this checkbox. This attorney has been going around in front of rental buildings with a megaphone and saying, anybody who wants $10,000, come talk to me. And then he'll go in and mail these little cards to tenants, or he'll put in post notes in front of like the property. Sometimes even trespassers go into the property and do it. And then he'll get a tenant who's going to say, especially he goes in low income housing areas, and he'll get a tenant and he'll look at their rental application and it didn't have this box. And then he files a lawsuit, and he's filed hundreds and hundreds of those lawsuits, and it's impossible to get them dismissed. He takes them to trial because the penalty purportedly is $10,000 per violation, but he can recover attorney fees. And then he'll ask for, on every case, like $300,000 in attorney fees or whatever he spent. So this to me tells me why everybody wants to use CAR forms, because what CAR does, I mean, this existed already on the CAR form, but what CAR does, every time there's a change, and this change happened in 2018, it goes back and it changes the form and make sure that this change exists. The same issue applies with, you know how during COVID you couldn't evict tenants, but you could, but there were certain situations where you were exempt, and if you didn't use the CAR form with the exempt box in there checked, you couldn't evict. So again, it's just an FYI. You want to make sure you use the CAR forms. Okay, this is a screening fee. I don't know if you see my cursor, it says $52.46. This is the maximum screening fee allowed per statute, and it was coded in 2020. If that's going to change, I'm sure CR will change the form. When you use it, it's just kind of a reminder, hey, I can't charge more than that. I can always charge less. So again, if you want to use these forms, there's really nothing you need to know about it, but it's just, this is why this change was made, is to make that clear, because some people don't know that and they'll charge a higher screening fee, and that's actually by statute that you can't. Non-contingent offer. Remember we talked about disclaimers. Here's another beautiful one. FYI, you know, the RPA says beware, but this is another bigger beware. Beware if you use a non-contingent offer. I think that's all I really wanted to talk about on this forum. Solar advisory questionnaire. This is a really nice form that helps with solar situations. I get so many calls on that. If you look at the RPA, remember we had like the solar advisory reference. Now you see the form that comes with it. And it's just basically, it's a new form that not only explains the different types of solars, what does it mean? If you purchase, it has to be transferred, or if it's leased, it has to be transferred. Might be a fee, you know, it talks about all that. But here, it has this like beautiful questionnaire. These are the things that you as a buyer may want to ask. You know, what's the age of the solar system, the name of the company that installed it, all these things. So it's kind of nice to give a little bit more information to your buyers so that we won't have this misunderstanding, miscommunication. They don't have to read a contract. They could just have the seller fill this out. It's kind of nice. So that's that. I know, more duty on you, more stuff to fill out with your clients. I know it's horrible. I get that. Buyer counteroffer, it was added here that wait. Oh, it's to clarify the difference between the offer price and the appraisal contingency amount will remain the same. So that is one thing that was added. But there's something else added on offers. I'll see it maybe on a different form. So remember, I'm going to talk about that. Cancellation. You know, this was probably the most issue that I've seen last year. People canceling all the time and not doing it correctly. First of all, let me make it clear. There are two cancellations because there are two contracts. There's the RPA and there's the escrow. You can cancel the RPA, but not cancel escrow. Why would that happen? Well, because escrow might have a deposit that the parties are fighting over. Does that give the buyer a right to file a lis pendens? No, they're not making a claim on title. There's just a deposit. So until that's resolved, escrow is not canceled, and they're keeping escrow open. But the contract is canceled. Okay, that's very simple. Now, not so, because sometimes you cancel contracts mutually, but you don't really cancel them mutually. You make an offer to cancel them mutually. For example, your buyer waives contingencies, but your buyer wants to cancel and get their deposit back. So they will create a cancellation form, and in that cancellation form, they will write mutual, because they're hoping that the seller will sign it and it's going to be mutual. The seller's not going to sign it and it's not mutual. So putting on the form that it's mutual is very confusing, because mutual sounds like it's a mutual cancellation and that both parties agree to it. And then you get into the dispute of, if the seller doesn't countersign, was it properly canceled? So yes, it was canceled, but it was canceled unilaterally. Okay, so CAR is explaining that now by calling it proposed mutual cancellation, and it explains the proposal. I had this lawsuit, okay? The the buyer sent an email to escrow and said, I'm sending you this cancellation. I'm going to decide by the end of the day if I'm going to cancel my contingency. It was an passive contingency. It was a commercial deal, so contingency was waived if it was not specifically if the buyer did not say, I'm canceling the contract. So he said, I'm going to decide until the end of the day if I am going to cancel the contract or waive the contingency. Just keep that with you. So instead, what she did is she gave it to the seller prematurely. So the seller looked at it and considered it as a canceled contract. The buyer then decided, I'm actually not going to cancel. So he sent her an email later and said, I'm not canceling. I argued I was directly representing the buyer in that case because he bought a $30 million commercial property that he was paying $24 million for it. So he had this $6 million equity built in. It was a really good deal for him, but he didn't know what he wanted to do yet. So the seller used that as an opportunity and said, great, the cancellation, the property, this was canceled, but the seller didn't countersign it. So my argument was that it was an offer to cancel that was not accepted, and it was withdrawn by the buyer before it was accepted. Okay, so this is where it kind of explains this part, that an offer could be revoked unless it's signed. So it's basically a proposed mutual cancellation. So that kind of clarifies that. And then that's about it. But I just wanted you to understand when you do fill out stuff, and the same thing actually I want to talk about when a seller cancels. The contract does allow the seller to unilaterally cancel. Like it says, when you send the buyer a demand to close and the buyer doesn't close escrow, you can cancel. It's a unilateral cancellation. What the seller would do is then they'll send a cancellation contract, and then they're going to try to sell it to somebody else. It's fine as far as I'm concerned, and it's legal. I just wanted you guys to know and explain to your clients, it's not, it's unilateral, and the buyer could come up with some excuse and say, no, it wasn't proper. I was going to do this. I have an excuse. So it's like, it's not perfect. So just make sure you understand when the cancellation is unilateral, that it's risky. It's fine, but it's risky. So that's what I wanted to say about that. We're really close to the end. Don't worry. And at the end of the hour, California Consumer Privacy Advisory. Yeah, just kind of tweaking it out. It's basically to correct something about the URL or something like that. Extension of time amendment. They call it a now amendment instead of addendum because it sounds more like part of the contract, amendment to the contract. An addendum is also an amendment, but that clarifies that. And then it talks about here about offer expiration. Let me see if I have here notes. It's just a time to respond. Yeah, that's it. Okay. Manufactured home, mobile home purchase addendum. This is just to
Not,
using the advisory, talk about the condition of the property.
Renat, can
Here
you
it
hear me?
is. Yes, yes,
Hi, sorry. David has a question. He says,
Yes.
so what happens? The buyer sue and win or go after seller for 6 million in equity?
So what happened in that, the buyer sued and the seller decided to sell it, but they agreed on a slightly higher price. It wasn't slightly higher price. And then the buyer wanted, the seller wanted the buyer to take over a loan that had a huge prepayment penalty, which had an interest rate a little bit higher. But by the time that they agreed on the price, the interest rate in the market were even higher than the loan. So by then it was worth for the buyer to just take over the seller loan. So the seller saved about $5 million prepayment penalty, and then they ended up closing the deal. Yeah, that's what happened in my case. So this is the like a TDS for the manufactured home. I think there's some. It just reformats it. That's all it is. Residential lease after sale. So this is if your seller is staying over as what is this? Oh, this is a lease after sale. The only thing about it is it talks about maximum security deposit that could be charged. Language was added to talk about the as is, and one thing was added to talk about smoking, that the seller tenant is not going to be responsible for smoking damage that already existed at the time of the lease. Okay, that's it. Seller counteroffer. Oh, remember, this is what I wanted to tell you about offers. Remember I told you that when you have the offers were changed a little bit. So if I'm a buyer, I'm going to make an offer. When you counteroffer to me, the counteroffer says everything is unchanged except. So that means that the offer and the counteroffer are read together. And you have to specifically say what you are excluding. A discrepancy occurred with respect to these prepayment closing costs, for example. If the closing cost is an amount and is not a percentage, is it going to stay the same when the price changes? Or if there's an appraisal gap, it would say something in the offer like buyer would agree to purchase the property up to 100,000 above appraisal. If it's appraised 100,000 less or something. Well, but if you change the price in these negotiations, is the 100,000 going to change if it's not a percentage? So it's basically that's the clarification that that anything that has to do with the appraisal gap or the closing costs is going to remain the same. So it's just to make it easier for you. And the same deal is on the multiple offer, same change. And then, wow, that was it. And it's exactly an hour. I can't believe I made it all in an hour.
Awesome.
Okay.
Any questions for Rinat that you have? Any specifics on the original purchase agreement, the buyer compensation agreements? Any questions whatsoever before we close it out? All right. Well, Rinat, thank you. Appreciate you.
My pleasure.
Wealth of information, tons to absorb, right? And this is, again, updates that happen on a regular basis, right? One in June and again in December. So be on the lookout. And if you have any questions, please reach out to me. I'll be more than happy to address, answer any questions, and we can always refer them to our legal team as well for a second opinion. So again, Rinat, thank you very much. Wait, I think
My pleasure.
question.
My
Does the
pleasure.
attorney have a contact information? Yeah, so basically how it works is we have to go through the real estate risk management team. There's a form that needs to be sent out, and then any of your questions will be related and the attorney will be appointed to you. So if you have any additional questions, feel free to reach out to me directly and I'll be more than happy to provide that process.
And just use the forms. I mean, it's like riding a bike. Yeah, the more you use them, the more you're going to be familiar with them and comfortable with them. So there's only so much I could say. You start using it, filling it out, and then maybe a question would arise or maybe it's clarified.
Yeah.
Simon, we have a real quick question over here. Yep.
Yeah.
When they sign the mediation section, if they go to mediation and they refuse to settle during mediation, are they still entitled to attorney fees? Just because they went to mediation?
Did you hear that?
Yes, yes, the
Yes.
answer is yes. Yes. So the mediation requirement is that if you do not ask to mediate as a buyer and you sue, or you do not agree to mediate as a seller if the buyer asks you to go to mediation, then if you end up prevailing, you won't get your attorney's fees. But if you go to mediation, that means that the buyer asked and the seller said yes, then neither side waives their right to attorney's fees if they prevail. Okay, awesome. You guys have a great weekend.
Thank you again. Appreciate everyone on the call. And again, Rinat, thank you very much for your time.
My pleasure.